I think they call him. That's head phone. Yeah, we can say your name first. Please say your name. And let's talk with
Okay, this is parties on Hunt.
What's the engine?
Ready.
I'm almost done.
Hello?
Please place yourself on mute if you're not on. If you're on, it's fine, but if you're not on, please place yourself on mute.
Calling case number 230-60506, People versus Melvin Hunt. Defendant is charged with count 1, felonious assault, count 2, domestic violence. This matter is up for a probable cause hearing. Appearances, please.
Good morning, Your Honor. Shelley Drain for the People, P number 60249.
And good morning, Your Honor, and your honorable staff. Attorney Quentin Docks, P number 79657, on behalf of my client, Mr. Melvin Hunt. Mr. Hunt, please state your full name for the record.
Melvin Leon Hunt.
All right, today's the day time set for probable cause conference. Attorney Drain, have you had the opportunity to turn over the discovery to Attorney Docks?
Yes.
All right, and Attorney Docks, you're in receipt of that discovery that she sent you at this point in time.
Yes, Your Honor.
All right, we're looking to set this matter for a preliminary exam on the date of January 5th. We have 9:15 on available. What time works best for you, Attorney Docks?
Can we do the 5th? Would be fine. It's later, the latest possible for me on the 5th.
Like the latest possible time. I can do it maybe 11:45. Does that work for you?
That works.
Okay, let's do 11:45 a.m. on January the 5th. At this point in time, Mr. Hunt, I see that you're on the phone today. This matter is going to be in person at 36th District Court. That means that you need to come down here. It's a live hearing in person on the date of January 5th at 11:45 a.m. Any concerns as to bond at this point in time, Attorney Drain?
No, Judge, thank you.
All right, you're welcome. All right, and so with that being said, his bond is going to continue. Mr. Hunt, make sure you're in person next Friday, okay?
Yes, ma'am. Yes, Your Honor.
All right. All right. If there's nothing further, that concludes this hearing. Thank you both.
Thank you.
Thank you.
You're welcome.
This is parties on Smith.
We're ready.
Calling case number 230-59351, People versus Jason Smith Jr. Defendant is charged with count 1, felony murder, count 2, murder first degree premeditated, count 3, robbery armed, count 4, 5, and 6, possession of a felony firearm. This matter is up for a probable cause hearing. Appearances, please.
Good morning, Your Honor. Anna Bickerstaff on behalf of the People, P82215.
And Judge Taylor, good morning to you and also to your staff. Good morning. Michael Woodyard, my P number is 64612. I'm a staff attorney at Neighborhood Defender Service of Detroit. We represent Mr. Smith. Mr. Smith is on the screen. Would you say good morning, sir, and say your name?
Good morning, Judge. My name is Jason Deshaun Smith Jr.
Good morning. Good morning to you all.
Good morning.
This time is the probable cause hearing. Attorney Bickerstaff, how have you done with getting over discovery of this particular matter?
Judge, I just found out yesterday Mr. Woodward was on this case. I sent over a proposed discovery order this morning. So I'm hoping he can let me know if he has any changes or anything to that, and then I can send it over as soon as that's signed.
Do you have my email address? Let me put it in the chat for you, okay?
Thank you, Judge.
Judge, I am reviewing that right now. I'm seeing that it includes some material. I wonder, I'm not going to review the whole thing while we're on the record here, but is there some type of protective order? Is that what this is? Or, I mean, what is the idea here?
Yes, it's just a protective order. The discovery is unredacted, and there also are some phone dumps that contain, other people's information that I obviously can't go through and redact a phone dump. So it's just for all that personal information not to be released to third parties.
Judge, we will resolve this issue promptly and get an appropriate document in front of the court right away.
Okay. All right, and Attorney Bickerstaff, I'm not able to access it, but I'll look for your information. I think I have it downstairs on my computer, and I'll send you an email with my information on it, okay? So I can just sign that discovery order. So with that being said, we're looking at preliminary examination dates on January 4th.
Judge, I would note real quick, I'm sorry to interrupt. While you're looking at your calendar, Mr. Smith is housed with the Michigan Department of Corrections. So we're going to need to make sure that he is brought to court on a writ, I imagine, which will take a bit of time.
How long does it typically take? Is it about 2 weeks that it takes to get them down from a writ usually?
I think generally a 2-week window from the time that the writ is served on the Michigan Department of Corrections is what they require. Although I'm not the expert on that.
No, I understand. So that brings us, I do have January 11th at 11:30 a.m. Does that work for either one of your calendars? If not, I'll have you come back and do this with Judge King so that he can make sure it's the right date.
I'm gonna, my camera is gonna go black for a moment, Judge.
Okay, that's fine. I understand, Attorney. What about you, Attorney?
For January 11th, I do have another exam before Judge King at 1:30. I do expect this exam to be about 4 witnesses and probably take a while, just so the court's aware.
So if you would like, you could come back on January 3rd and pick out a date that works with everyone's schedule, especially because we need to make sure we're getting down here from the way from the state, the state system. So,
Judge, I'm certainly comfortable and able to do that if the court thinks that's the best way to go forward. I would also indicate that a week from the 11th, on the 18th, I'm available if that is something the court can accommodate.
I got, so I'm gonna have both of you come back on January 3rd at 8:30 a.m. for an adjourned probable cause conference. And that way we can ensure that we know we can get Mr. Smith down here for his preliminary exam, or you can figure out exactly how that works. So I'll see everybody back at Judge King's on January 3rd at 8:30 a.m. for an adjourned PCC, okay?
Thank you, Judge.
Judge, that's terrific. Thank you. And you'll have the order in your email later on this morning, Ms. Bickerstaff.
And I'll get it back as soon as possible. That way she can share that information with you as soon as possible. Okay.
Perfect.
You're welcome. All right.
Thank you. Mr. Smith will be in touch.
This is parties on time. Calling case number 230-60489, People versus Damari Todd. Defendant is charged with count 1, home invasion first degree, count 2, felonious assault, count 3, domestic violence. This matter is up for a probable cause hearing. Appearances, please.
Good morning, Your Honor. Shelley Drain for the People, P number 60249.
Good morning, Judge. My name is Anthony Lewis. P number is 43876. I have no objection to this proceeding being conducted by Zoom. I do not see Mr. Todd on the screen, but I knew he was in your waiting room pursuant to the clerk.
Okay. There he is.
Mr. Todd, state your name for the record.
Damari Todd.
All right, this is the date time set for a probable cause conference. Attorney Drain, have you sent over discovery to Attorney Lewis yet?
Yes, Judge, I have. And I have had a discussion with defense counsel as well. He is also requesting the 911 calls. So I will make a request to make sure that I get those as soon as possible and turn those over to defense counsel. I'm also going to be contacting the complainant to see if she has any ring video available, and I will communicate the results of that conversation with defense counsel as well.
All right, so you've been in discussion, which is important. I appreciate that. All right, so we're looking to set this matter for a preliminary exam. Is that correct, Attorney Lewis?
That would be correct, Judge. We would be waiving the 21-day requirement. I know Attorney Drain is on top of getting 911 calls. It's just that they do not get them to her in the amount of time that the court gives us to prepare for exam. So I'm asking the court to give Attorney Drain some leeway on what the next court date would be, because I would definitely need that 911 recording.
What I'm going to do is I'm going to have everyone come back on January 3rd. The only date I have is January 5th right now for an adjourned PCC.
Judge, on January the 3rd, I'm already in an exam because I thought this was going to be in. On yesterday, we were in front of Judge Jefferson, and I was going to tell Judge Jefferson I wasn't available on the 3rd in the morning because I would be in an exam. So I'm not available in the morning on the 3rd.
What about January 2nd? Are you available at 8:30? It's just a probable cause hearing so that Judge King can find out. The date I have right now is January 5th for preliminary examination.
Well, Judge, I am available the morning of January the 2nd at 8:30. Okay. Mr. Todd, is that a good time for you also?
Yes, sir.
Judge, then we can come back on January the 2nd, 8:30 sharp.
Okay, that works for Mr. Lewis. You can figure out what date works best for everyone in this particular situation. Okay?
All right, Judge.
Thank you, Judge.
All right, no problem. All right, if there's nothing further, bond will continue.
Thank you, Judge.
You're welcome. Have a good day.
This is Curtis on Willoughby. Calling case number 230-605-3301. People versus Simi Floyd Willoughby. Defendant is charged with count 1, discharge weapon in the building and or at the building. Count 2, possession by felon. Count 3, 4, felonious assault. Count 5, 6, 7, 8 is possession of a felony firearm, and count 9 is domestic violence. This matters up for a probable cause hearing.
I talked to my lawyer.
Attorney Brush.
Yes, Mr. Willoughby, we talked yesterday. Is there anything we need to address right now in a breakout room?
Yeah.
Okay, I apologize. Could I get a breakout room?
Okay, I'd rather him tell you now as opposed in the middle of the hearing.
Thank you.
Well, when counting your 8th.
I ain't go to the break room.
Accept the prompt. There we go. All right. All right, well, I guess I'm going. It's fine with. Oh, he's. Parties on Williams.
Ready.
Stephen.
Which Williams? I'm sorry, Brandy Williams.
I apologize, Brandy Williams.
Okay, ready.
Morning.
Mark, you take your hat off for me, please, and get more on the camera, man.
Oh, I look kind of crazy, but
Don't worry about it. It's all right. You look fine.
okay.
Just pray. It's all right.
Calling case number 230-60555, People versus Brandy Williams. Defendant is charged with count 1, felonious assault, count 2, possession of a felony firearm, count 3, domestic violence. This matter is up for proper cause hearing. Appearances, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
And good morning, Your Honor. Brian Brown, P80560, appearing on behalf of Miss Brandy Williams, who is present. Miss Williams, please state your name for the record.
Brandy Williams, good morning.
Good morning. This is the Dave Johnson for probable cause conference. Mr. Brown, do you have discovery from Attorney Drain?
Yes, I do, Your Honor.
I know that she's good about it when it's a name that she can send it over to. So are we ready to pick our date for the preliminary exam? I'm looking at January 5th.
January 5th. Okay, can we do that later, maybe in the mornings? I have a preliminary examination scheduled at 9 o'clock. So we can do it possibly at 10:30.
Yep, that's perfect. I was gonna say 10, 10:30, 10:45. 10:30 works though. Let's do it at 10:30.
Okay, perfect.
15/24 at 10:30 a.m. Ms. Williams, that is in person. So I need you to come down to 36th District Court for a live preliminary examination. Come to the second floor for Judge King's courtroom, okay?
No problem.
All right. Attorney Drain, did you have something you needed to address at this time?
Yes, John, I just wanted to bring something to everyone's attention. The complainant in this case did contact our office and spoke with the victim advocate and indicated that they were receiving some threats from third parties, not the defendant, but from third parties. I was not able to get in touch with the complainant to get more specifics, but I just wanted to bring that to everyone's attention. Just so the court can reiterate, no third-party contact at all.
All right, Ms. Williams, she's not alleging that you did anything, just so you know, but she's alleging that she's notified that someone involved in this matter who may know both of you, who may know you. It could be someone even trying to protect you in some type of weird way. But tell your friends and family that no one is to have, and tell them that when they have contact with them, you get in trouble. Because if Attorney Drain brings that up again, then you're gonna be the one held responsible, even if you didn't ask for it to be done, even if you weren't the person who wanted it to be done, you get held accountable because you're the one who's before the court. So make sure you reiterate that to people that no one at all should be contacting this complainant with me saying anything at all about this matter. Okay, Ms.
Yes,
Williams?
absolutely. Absolutely. No problem at all.
So that you're the one who's in trouble, okay? Because they'll hold you accountable and they'll think they're trying to do something to help out and they'll mess you up and you'll be incarcerated until this matter is resolved. Okay?
Absolutely not. Thank you so much, but thank you.
All right, Ms. Williams. All right. If you have any more issues, Attorney Drain, please get all the information that you possibly can and present it to Judge King during the preliminary examination beforehand so that they can make sure they address bond. So this is very serious, Ms. Williams, because we need people to be able to.
Absolutely. This is my life.
I know. I can see the surprised look on your face. So she wasn't accusing you, but she was making it clear that someone thinks they're acting on your behalf potentially and saying stuff. So tell them to cut that out completely, okay?
Okay.
All right, so there's nothing further though. I will continue her bond at this time, but like I said, Attorney Drain, make sure you get a good note if this continues past today, because no one should feel that way when they're coming forward. Okay, Attorney Brown?
Yes, we would like to address her bond, please.
Okay, go ahead.
She's on a GPS tether. We have a couple requests. First and foremost, we're requesting that her hourly restriction be eliminated.
Yeah, put yourself on mute. Okay. All right, go ahead, Attorney. Sorry.
And we're requesting that her hourly restriction be lifted. She's currently working at Comcast, where she works up until 6:30 in the evening, and she's also going to school. And with the hour restriction, I believe she can only stay up to 6 o'clock. It's been a detriment to her working and her school also. And that's the first request. Second request, we're requesting that she be able to return back to her residence. She lives there solely by herself. She owns her house. She has a mortgage on her house. The complaining witness does not live with her at that particular residence. And on the night of this particular incident, my client is the individual who called the police to report a robbery where she was robbed of her phone and her ID by some individuals who are on the street. Detroit police didn't do their investigative work. However, that's not the case right now. The case is that the individuals who stole her ID have her ID and know exactly where she lives. She's not able to go back to her house and nobody's there to check on her house. So she wants to go there for one, to live, and two, to make sure that her house hasn't been broken into and ransacked by these particular individuals. And once again, I do reiterate that the complaining witness does not reside with her at that particular location, but she was, abiding by the course restrictions and hasn't been back to that location since then.
Attorney Drain, you have a response?
Yes. Your Honor, I will again try to contact the complainant and verify that she does not live at that location. And then I will contact defense counsel, and if the court is okay, maybe we could do a stipulated order that she could return back. I would have no objection to her returning back to her own home, as long as I can verify that the complainant does not live there. That's all. In terms of the hours, if she already has out hours, I'm not objecting to those being extended, as well as I have not, again, received any complaints that there has been any contact by the complainant in person, around the complainant, or by phone.
All right, so I am going to, at this point in time, extend. So what time does she have school until? You said she works until 6:30, and then she has school until when?
She has schools at different. She's online at school. To be honest with the court, she does take online classes, but she does for Comcast to 6:30. So the schooling is not so much of an issue. However, she does need to go back to her location to to get some supplies and school material.
Ms. Williams, let your attorney speak for you, okay? He's going to allocate. He's been doing a great job so far. Let him continue on. He knows that I know this is a frustrating situation. He's gonna speak on your behalf. So it sounds like, what time does she have to be at work in the morning? Ms. Williams, what time do you go to work in the morning? You can answer that for me.
Oh, I'm sorry. From 10 a.m. I start at 10 a.m.
Okay. So if I do 8 to 8, is that comfortable for everybody? 8 a.m. until 8 p.m. as hours of tethered?
Yes, Judge.
Would I be able to? Right now, I'm from 6 a.m. to 10 p.m.
Oh.
For what? Work? I asked you what time to go to work.
Oh no, I thought you were talking about my curfew currently.
Oh, I'm sorry. That was a misunderstanding. What time do you work?
Oh, I'm sorry. I do apologize. I work from 10 a.m. to 6:30 p.m. Eastern.
Okay, so if I do 8 a.m.
Call center type of. Oh, I'm sorry.
Okay. So if I do 8 a.m. to 8 p.m., what's wrong with that time?
Oh no, I'm fine with it. I was just wondering, like the current time that I have, the 6 a.m. to 10 p.m. is fine, because like 8 is kind of cutting it.
What you're saying?
Yeah.
Well, why do you change it to Attorney Brown? She said she has 6 a.m. to 10 p.m. right now.
I spoke with her and she indicated that it was trouble with her work schedule. I mean, we spoke about this just yesterday, matter of fact. So I'm not sure.
Oh no. I was trying to explain. My apologies. I'm getting it all misconfused. I don't want to confuse anything, but I'm okay with it, because I was just wondering, like, does it have to be like, can I go home, or do I have to have a curfew at all? Like, that's
She's more
probably
concerned about going home. Okay, so they're gonna check and make sure that the complaining witness at this point in time doesn't live at your home. If they do not, I'm going to sign an order saying that you can go back to your house.
Would I have to still have a restriction, like as far as the time of me going home?
Yes, it would still be 6 a.m. to 10 p.m. for the test. Okay.
And one more quick question. I'm sorry, but my vehicle, because I don't have any way to get around.
Where is your vehicle? Do you have it?
Her vehicle was I guess towed by Detroit police because of the incident. So maybe I need to contact Ms. Drain, who can possibly contact Officer
I was gonna say, have an offline conversation about that, and if it's presented with anything, then, no, I wasn't talking to you, Ms. Williams. I was talking to Attorney Brown. Talk to Attorney Drain and see if anything can be done about the vehicle. If it's not a part of the incident, there may be able to be something to be done, but if it was alleged to be a part of the incident, then I know Attorney Drain may not be able to do anything because of the way that it is. So we're gonna try, Ms. Williams, to do the best that we can with this. We want to try and get you back to your residence. It seems like your tether is okay, the hours, 6 a.m. to 10 p.m. At this point in time, nothing happens after 10 p.m. anyways. Right now, you want to stay tight and get this resolved, okay? Just so you know.
Yes, ma'am. Absolutely, absolutely.
Because you don't want to get it caught up in anything. So I'm gonna leave those restrictions on for right now. As long as it's not work, we are gonna try and get you back to your residence, okay?
Yes, my regular life.
All right,
Okay.
thank
All right. If there's nothing further from any party, I'm going to conclude this hearing. Thank you all so much.
Thank you for your time.
You're welcome, of course, thank you. All right.
Okay, we're back on the record with case number 230-605-3301, People versus Sammy Willoughby. Ms. Brush.
Good morning, Neighborhood Defender Service by Summers Brush, P number 85828, appearing on behalf of Simi Willoughby, who is present via Zoom. Mr. Willoughby, please state your name for the record.
Simi Floyd Willoughby.
Attorney Drain, please state your name for the record.
Good morning, Your Honor. Shelley Drain for the People, P number 60249.
And I know you're just finding out that Ms. Brush is the assigned counsel for this. Are you going to be able to send her over discovery soon in this particular matter?
I can send it again. I know this was a refile. I believe that was also with NDS. So I'm Ms. Brush, do you have the discovery or no?
I have the paper discovery. I think it's in a different attorney's closed file. The rest of it. So if you could resend it, just for those purposes. Thank you.
I'll just resend it. Thanks. Mm-hmm.
Right, if you resend that, that would be perfect.
Yes.
All right, so we're looking at a preliminary exam date on the date of January 5th.
Yes, that works, Your Honor.
Right, January 5th. What time works best for you? I have a 9:15. I know, did we already schedule one with you, Ms. Brush, for that day?
Yes, I scheduled one for 9 already on the 5th.
Okay. Will you do 9:15 or do you want to do 9:30? How do you want to do it?
9:15 should work.
Okay. All right, so we'll do it at 9:15 a.m. Do you have any other concerns at this point in time?
No, Your Honor.
No, Your Honor.
None from the attorney? All right. So at this time, the file will continue as is. We'll see everyone back on 9:15 a.m. on January 5th. That is going to be in person, sir, so they'll bring you here. If you haven't found it out by that point in time, they'll bring you over to 36th District Court to have a live examination, okay, in this particular matter, okay? If there's nothing further, that concludes this hearing. We'll see everybody next Friday at 9:15 a.m. for a preliminary exam.
Thank you, Judge.
You're welcome. Thank you.
We're done.
Yeah. Do you have anybody else? Yes, we are finished. Did you have Mr. Watkins in there? Because I know Attorney Washington, he wanted to talk to someone, Mr. Williams or somebody, Mr. Washington?
Yes, Ron, that's Sherrod Walker.
Sherrod Walker, okay.
Oh, Sherrod Walker. My bad.
Mr. Walker?
Watkins.
Okay.
Have a seat.
Watkins.
Have a seat, man.
You're not gonna call it. No.
The wrong side of you.
I'm on Watkins.
Come on, Mr. Walker. This ain't your house. You're gonna hit shit in here.
Are you Mr. Walker?
Yes, ma'am.
All right, Mr. Walker, we're gonna put you into a breakout room with your attorney, Mr. Earl Washington. He wanted to talk to you before this hearing began, okay?
Okay.
Yeah.
Okay, Wayne County Jail, you have to set the prompt. Here we go. Now. This party's on Williams. Stephen. Stephen, yes. Calling case number 1 second, sir. Calling case number 230-60559. People versus Stephen Williams. Defendant is charged with count 1, felonious assault, count 2, domestic violence. This matter is up for a probable cause hearing. Appearances, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
Good morning, Your Honor. Neighborhood Defender Service by Summers Brush, number 85828, appearing on behalf of Stephen Williams, who is present via Zoom today. Mr. Williams, please state your name for the record.
Stephen Williams.
Right, today's the date time set for a probable cause conference. How are we proceeding in this matter? Attorney Drain, are you gonna be able to send over Ms. Brush the discovery of this particular matter?
Yes, I can send her over the discovery.
Fantastic. All right, so with Attorney Brush, you're gonna say something?
Yes, I'm looking to set this for an in-person preliminary examination.
All right, we're gonna keep with that same date of January 5th.
Yes, might as well.
Do you want to set this one at 9:30 or do you want to set it at 9:45 a.m.?
Can we do 9:45?
We can. I'm gonna ask to give you a little break just in case you need it. So we'll set this matter at 9:45 a.m. Any issues as to bond at this time, Attorney Drain?
No, Judge.
Your Honor, if I can address bond condition, right now, Mr. Williams, a condition of his bond is no driving. His career, his job involves driving. He has a CPL, or CDL, sorry. I'm used to saying CPLs. He has a CDL, commercial driving license, and he does car transportation. So having the bond condition where he cannot drive is, of course, impeding his ability to work and put food on the table for himself. So I would ask that condition be removed. He has the presumption of innocence in this case, and in the alternative, I'd ask that he be able to drive between working hours, let's 6 a.m. to 8 p.m. Typically, he's done with work by 8 p.m. most days. The allegations in this case happened late at night. So if the court is concerned, I'd ask that he be given time in the day to drive for work purposes.
They can't drive over the road, so he can't leave the state of Michigan. I don't think we've ever done no driving. Is it that he wants to leave the state of Michigan to transport? Is that what it is?
I'm looking at the register of actions. It says no weapons, no driving, no drinking. And he doesn't leave, from my understanding, he's just transporting cars around the state.
Attorney Drain?
So it looks like the reason that was put in here is because the felonious assault, the weapon used was the motor vehicle. And so that was the assault. So I think that is the reason why. I've never seen that either. So I'm not.
I know.
Go ahead.
No worries. I was gonna say, before you get to some of the people, because this is the tight one. Mr. Williams, the allegation is that you used the vehicle. And it's just the allegation right now that you used the vehicle, and that's the assaultive weapon of choice. And that's why they put this restriction. Now, I've never seen it before. And neither has Attorney Drain, it sounds like. But if I live this, it sounds like you drive. If I lift this and anything happens, then that's a grave concern to me, Mr. Williams. That's why we have to, before we do stuff, potentially. Because we never know how to affect everything else, right?
Right, I understand. There will be no problems with me. No
Senator, I'll let
problem.
you state any objections you may have on the record at this point in time. I don't want to take that away from you.
I have no objection, Your Honor.
Okay.
Thank you.
At this time, I am going to lift that restriction. You can drive, but do not use the vehicle as a weapon. Do you understand, Mr. Williams?
Yes, ma'am, I do.
Okay.
Yes.
Driven on the roads, not used as weapons potentially. I know these are allegations, but not used as weapons for anything. Okay, sir?
Yes, ma'am.
All right, so I'll lift that restriction. I don't know, we'll figure out how to go about doing that for you, Attorney Brush. I don't know if an order needs to be provided, or we can just take it out of the order that he has this restriction on not driving.
Yes, if the court would want me to prepare an order, I can do that.
Can you please, and I'll sign it. Okay.
And I'll send it over, yeah. Thank you.
Anything else that needs to be addressed at this time, Attorney Drain? We don't have any issues other than that one concern.
Nothing further. Thank you, Judge.
All right, just had to check to make sure. All right, if there's nothing further, then we'll see you. Yes, Mr. Williams.
I was just about to ask, the date was the 5th, correct?
Yep, I was gonna repeat it because we had this long discussion.
Okay.
January 5th in person at 9:45 a.m. That's at
All right.
36th District, physically in person, okay?
Yes, ma'am.
Right, if there's nothing further, you are all set. Thank you all so much.
Thank you.
Thank you.
Thank you.
Madam Clerk, this is Magaton. I'm here on LaPortia Dixon. I was directed to another courtroom until I was told I was supposed to be here. So I just want to let the court know.
Okay, thank you.
Mr. Lewis, did you need something?
Yes, Judge, I would ask that if I could be called again at the end of your docket, or when it's appropriate to recall Mr. Todd again.
Okay.
And he should be in the waiting room.
Okay. But this time we're waiting on right now, Jill. So.
Hello?
Hello.
Okay, Mr.
Damari Todd?
We have you, Mr. Todd.
Okay.
Recalling case number 230-604-8901. People versus Damari Todd.
Here's this once again for the record, starting with counsel for the people.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
Good morning, Your Honor. Please support Anthony Lewis, 43876. On behalf of Mr. Todd, we have no objection to this proceeding being conducted by Zoom. Mr. Todd, state your name for the record.
Damari Todd.
I think we already caught this matter, but counsel check back in. Attorney Lewis,
Yes.
what seems to be concerned?
Judge, the concern is that when this case was assigned, we appeared in court yesterday in front of Judge Jefferson. And Mr. Todd missed his check-in with his tether person on yesterday because we were in court most of the time period that he had in order to check in with Corporal Smith. And he came to learn of this because when we disconnected from you just about 10 or 15 minutes ago, I called and talked with him about the tether because he had asked me to ask for it to be removed. And I told him I spoke to the prosecutor about it, and I just thought that it was an ordinary tether for him to stay away from the complaining witness and that he could freely move about as long as he stayed out of that restricted area. He informs me that it's a house arrest tether and that he's only allowed to go to work. Now, from the time that he was released on December the 19th, he tried to make arrangements with Corporal Smith to spend the holiday with his son that was turning 1 and spend Christmas with his parents, but he was never able to get in contact with Corporal Smith to make those arrangements so that he could leave his home on the days that he desired to leave the home. And so it's a twofold reason, the reason why we came back in, because I don't want, if the violation comes in, I want the court to be made aware of why he didn't call Corporal Smith on yesterday. And I'm now asking for consideration to just have the tether be restricted to around the complaining witness area where she lives, because Corporal Smith is not getting in touch with my client when he's going through the right procedures to leave the home on at other times other than going to work.
But he's not gonna be able to. If it's house arrest, he's only gonna be able to go during those restricted hours or to and from that one location. I know it's the holiday. He would have probably enjoyed being able to do that, but these are very serious allegations, Attorney Lewis. It's his #1 charge is home invasion first degree.
And Judge, I understand that, and I discussed that with counsel, and that's the one that we're contesting, and I can put it on the record here and now.
I'm not gonna be the one who Go ahead.
Judge, my client did not enter the home. So
I can't, decide that today. Attorney Drain, did you have anything you wanted to say?
As far as a possible tether violation, I suppose we would deal with that if it arises, but I think defense counsel has already stated what needed to be stated for the record. In terms of changing the tether situation and the hours, I don't know why there needs to be a court order at this time. I think that he should still follow the proper procedures and get in touch with the tether person to coordinate that. That's what I would ask for.
They selected a house arrest. It's for a reason. And I think it's because of the serious nature of it. And they're allowing you to go to work. So next Friday is the day, no, the 2nd is the date that y'all will pick the preliminary exam. You can address that with Judge Keith, Attorney Lewis, reducing his hours or changing his hours of tether at this point in time. I'm not inclined to do so, just because it still allows him to go to work. Usually I'll adjust it if it affects the ability for him to make some source of income at this point in time and sustain livelihood. He can still do that. I know it's unfortunate he's not able to see family and friends right now, but they can potentially, sounds like, come to his location as well. I don't know how that goes. I don't get into people's family business and dynamics, but as long as he's able to at least go to work and fend for himself while these proceedings are taking place, I'm going to keep it as is for right now.
All right, Judge, and I thank you for the opportunity to be heard.
You're welcome, and you can readdress it, like I said, on the 2nd with Judge King to see if he can give you something different. But right now, I'm gonna keep his tether hours. He is allowed to go to work. I believe that is sufficient at this point in time. And you can address a change or potential change to tether hours on the 2nd, okay?
Okay, Judge, thank you.
You're welcome. Have a good day, okay?
You too.
Thank you.
Bye now.
Have a good morning.
You too. Have a good rest of your morning, okay?
Okay.
Okay, this is on Walker, calling case number 230-60523. Strike that. Calling case number 230-6054201. People versus Sherrod Walker. Defendant is charged with count 1, home invasion, second degree. Count 2, larceny of a firearm. Count 3, possession of a felony firearm. Count 4, aggravated stalking. Count 5, 6, 7, possession of a felony firearm. And count 8, malicious destruction of personal property less than $200. This matter is up for a probable cause hearing. Appearances, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
Good morning, Your Honor. Pleasure seeing you. Earl Washington, Neighborhood Defender Service, P31383, on behalf of Mr. Sherrod Walker. And if you can state your name, Mr. Walker.
Right, this is the time and date set for our probable cause conference. Attorney Drain, have you had the opportunity to send Mr. Washington or Attorney Washington the discovery yet?
Your Honor, I actually just sent an evidence.com link, which contains the paper and digital discovery for this case.
All right, fantastic.
Okay.
All right, Mr. Washington should be in receipt of that soon. We're looking for preliminary exam dates. Is that correct, Mr. Washington?
Yes, Your Honor.
Looking for January the 5th. Right now, the times I have available are 9:30 a.m. and then after that, 10, 10:30, 10:15. No, not at 10:30, 10:15, 10:45. What time works best with you on that day, sir?
Did you say 10 o'clock, Your Honor?
I do have a 10 o'clock available.
Okay. Yeah, if you could set that for 10 o'clock, that would be highly appreciative. Thank you.
Okay, so we'll set this matter for January 5th at 10 a.m. It's going to be in person, so he'll be transported over here to 36th District Court for this hearing. Anything else from you, Mr. Washington, at this time?
Yes, I have nothing further, Your Honor. Wishing you a happy new year.
Thank you. What about you, Attorney Drain?
Nothing, Judge. Thank you.
All right. All right, if there's nothing further, we will see everyone on January the 5th at 10 a.m. for the preliminary examination in front of Judge Lee, okay?
All right. Thank you. Bye.
All right, good to see you, Mr. Washington.
Good seeing you.
You're all set, Mr. Walker?
Parties on Watkins.
Excuse me, Judge.
Yes.
Is there any way I can talk to Mr. Washington again?
He logged off, I'm sorry. Did he give you his information?
No, he didn't.
Attorney Brush, do you happen to have his information or some information you can share with Mr.? I know y'all work in the same
Yes.
office.
Let me, I can,
Now they file in this case, all at the same time.
Ms. Burwell.
I can pull up Mr. Washington's phone number and
Thank you so much.
and give it to him in a breakout room. I don't
Thank you.
want to say it publicly.
No, I totally understand. Thank you, Ms. Brush.
Thank you so much.
I can go in a breakout room with him whenever. Thank you.
Okay, Wayne County, who we have?
Jerome Watkins.
Attorney Barnwell, have you left? I know she had to run next door to handle it. Oh, maybe we can. Fantastic. No. Okay, she said no. Okay. We gotta skip over Mr. Watkins. Do you have Mr. Long or no?
If I have Long. Okay, can we get Long, please?
Instead, we come back, Mr. Watkins. Your attorney is on another hearing right now with different courtroom, okay?
Ms. Long, then what you say?
Morning.
Ms. Long, Judge Taylor.
Thank you. Good, hello, good to see you.
Good morning, Your
Good morning.
Calling case number 230-60480, People versus Nadia Long. Defendant is charged with count 1, home invasion first degree, count 2, unlawful imprisonment, as well as count 3. Defendant is a habitual offender, has a second offense notice. This matter is up for a proper cause hearing. Appearances, please.
Good morning, Your Honor. Brittany Johnson on behalf of the people, P83513.
Good morning, Your Honor. Neighborhood Defender Service by Summers Brush, P number 85828. Appearing on behalf of Nandy Long, who is present via Zoom. Ms. Long, please state your name for the record.
Nandy Long.
Today's date time set for a probable cause conference. I'm Attorney Johnson. Are you aware that Ms. Brush was over this case, or are you just finding out today?
I'm just finding out today, Judge. I had sent discovery to Kim Michon, which is from her her office. However, I would be requesting to refer this defendant for competency today.
Okay. Attorney Brush.
Your Honor, I would object to that. At this point, I would ask to set this for preliminary examination. Ms. Long has right to a preliminary examination. I have met with her in the jail. After speaking to her, having a meeting with her, I don't believe that she needs to be referred for competency at this time.
And Judge, the only reason that I'm requesting that is because there is a note on the ROA from either the arraignment judge or from the bond redetermination judge that does request that we set her for competency as soon as we can. A little bit of background, this defendant did come into her cousin's home, who was the foster care mother of her own children, pushed her, took the children, and took them to a second location. This was the day after she was due to be sentenced for kidnapping custodial interference, something that she had pled to a couple of months back. And so based on that information, coupled with the fact that after she was taken into custody, she did attempt to escape. She crawled through the ceiling at the hospital and had to be taken out of the ceiling by another officer. And so for all of that, the people are requesting competency.
Ms. Long, this is not an opportunity for you to speak.
I'm sorry, Your Honor.
It's okay. Just hold tight. You have an attorney who's going to allocate on your behalf. I know it's frustrating when you hear stuff being said about you, but we're going to have the attorneys talk about it. You hold tight. Okay, put that mask up for a moment so that way you don't attempt to say anything while your attorney argues on your behalf. Okay, Attorney Johnson, you can continue.
And Judge, for that reason, I believe that she should be referred for competency and at that probably criminal responsibility, since she'll be at the forensic center for that. Thank you.
If I could respond, I understand the allegations are serious in this case. I would like to do some follow-up investigation prior to a preliminary before coming to a decision about whether she should be referred for competency here. There has been some information given to me that the CPS worker in this case has received a change in the story from the custodial guardian in this matter. And in order to do my due diligence in this case, and I'd ask that we still schedule this for a preliminary examination, and at the preliminary examination, or prior to the preliminary examination, after I'm able to do some work on this case, we can come to a decision about whether Ms. Long should be referred for competency.
Based on what you said, although those are some allegations, I didn't hear anything in there. She's able to competently talk to her attorneys to determine right from wrong. As Attorney Brush, have you had the opportunity to speak to Ms. Long yet or no?
Yes, we did speak yesterday at the jail.
I only pause because it takes so long for it to come back, and I don't know that typically we're in conjunction with each other for the request for competency. It doesn't sound like just because they put it on the form, they may just be saying because of all of the things that she's done who would do this. But I'm neither a mother nor having kids, so I don't know what you would really want to do these things. Not excusing any type of you're gonna stay right there, just so you know, Ms. Long, I'm not changing any type of so we get this all squared away. I'm inclined, this is what I'm inclined to do. You can either have your preliminary examination date, and then at that time, readdress it with Judge King and see if he believes that it rises to that level. I don't know, Attorney Johnson, you haven't had a conversation with her, so now I'm concerned, because the things that you described sound like someone trying to get out of jail, potentially, someone going back to get their kids. I don't know if it rises to that level of not understanding the consequences of their behavior. So I can either set this for a preliminary exam, or I can set it for a probable cause conference. What do you think would be better in this particular matter?
Judge, I think we should set it for a probable cause conference, being as Ms. Brush hasn't had the opportunity to review any of this discovery.
Okay. So the date I have is January 3rd. That's only 2 days away from the time that will be a preliminary exam. But I can do January 3rd at 8:30 a.m.
I can do that, Judge, and we can leave the exam on the 5th as well. I think that will work out.
Yes,
you want to do it like that?
That works.
Okay, all right. So what I'm gonna do is I'm gonna set it for. Can I just set it for the preliminary exam, and beforehand you can tell Judge King if you really think that it rises to that level of it?
Yes.
Sure.
That makes sense.
So I'm gonna set it for 1-5. I have it 10 o'clock now, 10:30 on that day. You wanna do 11, Ms. Brush, or 10:45?
10:45 is good.
Okay. All
I'll
right,
already
so we'll
be here.
I understand. I didn't know how much of a time space you wanted.
Yeah.
I also have a 10:15 if you want that instead.
Yeah, I'll do 10:15 actually. So.
All right, 10:15.
That works for Ms. Johnson.
Yep. Thank you.
Attorney Johnson, this doesn't rule out the fact that you can re-ask Judge King if you really do think, and Attorney Brush, I just advise you, please talk to your client once again if you can. If you do see some issues that you think will hinder her ability to be able to rise to a level of criminal responsibility or competency in this particular matter, please inform the court. You can even let him know that Attorney Johnson asked for it and I said no at this time, based on the information I was given. So we'll see everybody. You'll be brought over here, Ms. Long, from the Wayne County Jail on that date to participate in the preliminary exam. I will let you argue bond if you want to with Attorney Brush, but at this point in time, I can tell you based on the allegations and what's been alleged previously of happening, I'm not that inclined to change.
Yes, and I understand, Your Honor. I do. I would like to address it for Ms. Long since we have talked about it. I'm asking for a reduction in bond today to $50,000, 10%. Ms. Long is indigent. I think $500,000 is excessively high and a bond that she would never be able to pay in this matter. And it's I think it's the court's responsibility to consider her ability to pay and consider alternative means for her to make sure that she comes to court and complies with the conditions of her bond. I think 50,000, 10% with house arrest, home confinement, no leaving under any circumstances would be a way to ensure that the community is safe and that she appears in court. I know that there was a bench warrant from Oakland County out for her when she picked up this case. After talking to Miss Long, it seems that was honestly a misunderstanding. She was at court and then went to the bathroom, and then her case was called and she was told it was too late. Whether that was Miss Long, a misunderstanding of situation, whether things work differently in Oakland County, I don't know. But that was her understanding of the events that day, and then a warrant was issued. But she was there to be sentenced. And then the big thing here is Miss Long is experiencing some health issues in jail with this high bond, with no ability of her to get out. She is experiencing a lot of hardship. Specifically, right now she has an ectopic pregnancy. She had a procedure scheduled at a health clinic on January 5th because of the dangerousness of this pregnancy, and she cannot deal with that right as of now because of her custody status. And before this occurred, she does have a job. She's working at Popeye's Chicken on Warren and Connor. I think that job is still there for her. But understanding that she'd probably be on house arrest. And before this, she was also a student at Wayne State. And I'll leave it at that. So I'd ask for that reduction.
Judge, I have made my representations already on the record. I will just note that when she missed that sentencing date for parental kidnapping case regarding the same children, she's alleged to have taken those children the following day, and then later that day attempted to escape from police custody by climbing into the ceiling of the Detroit Receiving Hospital. And for that, I don't believe that she would be able to follow court orders.
At this time, this is some serious allegations that you missed a court date, ma'am, for the same children. And so I feel like, as the court, that your ability to handle these matters will be best served to the kids if you remain in custody at this point in time. The danger to society as a whole is not my concern. Attorney Brush, is danger to these children. They are the ones who are suffering the most in this particular matter. If they have guardianship right now, that is where they are to stay until this matter is resolved. And the fact that you have a brand new case with the same set of children before you even resolve the entire other case is of grave concern to the court at this point in time. And if she has the procedure next Friday, is that going to be a good day for her? Because she has her preliminary exam that day, so she needs to rest until that time anyway. This will ensure that she rests until the time of next Friday when she is going to have this preliminary exam and potentially a procedure. So at this point in time, I don't see a reason why I should reduce the bond to ensure that safety to her children at this point.
I will not go nowhere near them. I promise y'all. I won't go nowhere near them.
That's probably what you told the other. Listen, Miss Long. That's what you told the other.
No,
Miss Long, you probably told the other court too. I'm not saying that you don't love your kids, that you don't want to be reunited with them, but you have to follow whatever orders have been put into place.
They told me to come over there and bring the Christmas gift, and that's what I did.
You can't do anything that goes against what the court told you. If the court told you that you could not go near your kids, you cannot listen to a common citizen over the orders of a court, ever. And that's what got you in this predicament, is because you decided that the court's orders and the court's rules can be circumvented because someone told you, oh, just come over. And you see what happened. You came over and allegedly they called the police and said she can't be here. So instead of listening to what the court said, and the court told you no, that's what they told you, no. And you said, oh, but they said I could.
please.
So this is the decision that you made, and that needs to ring true in your head when people tell you not to follow court orders. What the court says is true, 100%. So next Friday is your day. Obviously, Attorney Brush already said she's gonna follow up with some information that she's been given to make sure that everything is okay for next Friday. She can have that. Even if I lowered it, it would still be a high bond, just so you know. So I don't even want to touch it. It's at 500,000, I would do 250,000, but I'm not gonna touch it. Because at this point in time, Ms. Long, you need to finish this up. Because there's too much uncertainty about whether or not you're gonna show back. Now her file does need to be marked medical, if it's not marked medical. I know this is tough, Ms. Long. Ms. Long, this is why you got to follow what the court said. That's why I'm assuming, and these are assumptions, that the kids were not in your control because you didn't follow what the court asked you to do originally. Ms. Long. I'm talking about prior to all of this happening. We're not even talking about
everything. I was at court. I just went to the bathroom and they called my case. And when I went to go visit my kids at CPS, they said I couldn't see my kids because I had a bench warrant. And then I had my cousin told me to come over and bring their Christmas gifts. I took their Christmas gifts over there. She told me to take them to McDonald's. I took them to McDonald's. When I got back to her house, the police was there.
Did the court say that you could have your kids at that time? Are you listening, Ms. Long? Okay, no, Ms. Long, answer my question. Did the courts tell you to take your kids anywhere, unsupervised?
No, but Ashley did.
No, the answer is no. So even if a family member, and I'm sad for you, because this family member, if what you're alleging is true, is correct, this family member set you up, potentially.
Yeah, basically.
Right? But that's your responsibility. Your family member is not here in court today. It's you. It's your responsibility. It's your choice. It's your decision. And you made that decision, Ms. Long. And I grieved for you because you made that decision. But you chose to do it. I could imagine the amount that you miss your children, but now since you didn't even finish out the other one. She hasn't been sentenced yet, Ms. Brush, in her other case, has she?
I went to court though. I was there.
I'm not talking about court. I'm talking about you haven't even been sentenced in your other case yet. Is that
I
correct?
was sentenced that day, but they changed the date, I guess. I was there at court. I was there. I just went to the bathroom. They called my case. I was there though.
Attorney Brush. I'm sorry.
Yes, Your Honor. So
has she been sentenced in her other case yet?
no, I don't believe she's been sentenced. Yeah. And I think I will be getting in touch with her lawyer over there to see if how we can get her arraigned on that warrant, because I don't think she has been yet.
You gotta let the process pull out in its entirety. And you have to allow yourself to follow whatever rules the court says.
And they talk about I can't see the ceiling receiver. I woke up from out of a seizure, and it was a whole bunch of doctors and police officers over me. I went to the bathroom. They didn't even have me chained to the bed or nothing. So they got me messed up. Ain't nobody trying to escape nothing.
All right. Well, this isn't about you trying to escape or not. This is about you not finishing what you need to do for these children, and the fact that I can't let you out because the kids are still out and about. And if what is true, listen, Ms. Long, stop talking. Stop talking, Ms. Long. If I let you out, my concern is that you're gonna go back over there because one of your family members will say, no, Ms. Long, stop talking. We're done having you speak at this point in time. I'm not changing bond. We're gonna stay there until next Friday. We'll see everybody in person here at 36th District Court for your preliminary exam. Ms. Long, I can't. Because you may allow a family member to persuade you to come over there and see your kids, and guess what they're gonna do? And then you're gonna be right back here with additional charges. They don't say you ain't do this and you already got a case. They say let's add some charges on you too. And that's not what you want. So take care of this. Have your attorney help you take care of your other matter. And then just use this time to reflect on what's going on and what's happening in your life. All right, that concludes this hearing. Thank you.
Thank you, Judge.
You're welcome. All right, Ms. Long.
Wayne County Jail, can we get Watkins, please?
Michael Walker?
I'm putting on the female side like this, so let's.
Okay, so we can do Dixon, okay. You, LaPortia Dixon, ma'am?
Yes.
Okay.
Calling case number 230-60496, People versus LaPortia Dixon. Defendant is charged with count 1 and count 2, assault with intent to murder. Count 3 and 4, assault with intent to rape by harmless murder or by strangulation. Count 5, failure to stop at the scene of an accident resulting in serious impairment or death. Count 6, reckless driving causing serious impairment or impairment of a body function. Count 7, 8, felonious assault. Count 9, domestic violence. Defendant had commission of a felon with motivated advisory. This matter is up for a probable cause hearing. Appearances, please.
Good morning, Your Honor. Bryn Kurt on behalf of the people, P84009.
Good morning, Your Honor. I'm Mark Magidson on behalf of LaPortia Dixon, P number 25581. Ms. Dixon, could you identify yourself for the court, please?
Yes, hi, LaPortia Dixon.
All right, this is the date and time set for a probable cause conference in this particular matter. Attorney Kurt, have you turned over discovery to Attorney Magnuson yet?
Yes, Your Honor. All paper discovery was turned over a couple of days ago, and I sent over a link for digital. I'm sorry, just a moment. I'm sorry, Your Honor. I'm in another courthouse. And I did send over a link this morning for digital discovery.
I did see that link. I haven't opened it yet, but I did see the link. So I think we're good on the discovery.
All right, so we're looking to set this matter for a preliminary exam, is that correct?
Yes, Your Honor.
Yes, Your Honor.
What's the highest charge again?
I'm sorry, Your Honor.
I was looking for the highest charge on her, so I don't know what dates. Judge King doesn't certain that.
Well, it's not murder, it's just assault.
Okay. All right, so the date we're looking at is January 5th.
That is a good day for the people, Your Honor.
What's the earliest that you have, Judge?
The earliest I have is, I believe, 9:30 a.m.
I'll take that if that's good with the people.
Unfortunately, I should be able to make it work, Your Honor.
Sure. Okay. All right, so we'll do it at 9:30 a.m. on January the 5th, 2024. It is going to be in person, so we'll be live here at 36th District Court. All right. Do we have any other concerns at this time?
The only thing I would request, Judge, is if you could make a referral to for a DSU or pretrial services report.
I sure will. I'll make a referral for trial services DSU report so that we can get some background and information about it. This is a pretty serious charge. That's the top charge. So we want to make sure that we have information.
What is the bond now, Judge, if you know?
Let me see. Give me 1 second. I'll tell you.
I believe it's 500,000 with house arrest, GPS tether, Your Honor, and I think alcohol testing.
Okay.
Or it's an alcohol tether with house arrest. But I do know it's a tether. I forget which tether though.
Okay.
It says 2 million. Is that wrong?
Oh, 2 million? Oh, that's right. That's right. I'm sorry.
$2 million cash. That's what the bond is set at right now.
2 million?
Yes.
Oh, well, okay. So I guess we'll address all that once we get the report back.
Get the report and then have it addressed that day. So I'm going to have it set for January 5th at 9:30 a.m. Her bond will remain the same until we get that DSU report, okay?
Thank you, Your Honor.
Okay, we'll see you then. Have a good New Year, and Ms. Dixon, I'll be in touch, okay?
Okay.
Okay, thank you.
Yeah.
Calling case number 230-60499, People versus Michael Watkins. Defendant is charged with count 1, felonious assault, count 2, felonious assault, count 3 and 4, possession of a felony firearm, count 5, domestic violence. This matter is up for a probable cause hearing at Phoenix Schools.
Good morning, Your Honor. Shelley Drain for the People, P number 60249.
Unmute yourself, Attorney Barnwell. I know, unmute yourself.
Good morning. Good morning, Your Honor. Whitney Burnwell, P42505, on behalf of Mr. Michael Watkins.
All right, Mr. Watkins, state your name for the record, please.
Michael Jerome Watkins.
All right. Today's the day and time set for a probable cause hearing. Attorney Barnwell, do you have the discovery from Attorney Frank?
I do. I have both digital and paper, and we were in front of a different judge yesterday, and they realized it's a king. It's more appropriate for king.
Okay, because of the domestic violence charge on it. Is that correct? Okay. All right, so we're going to set this matter hopefully for a preliminary examination. We're looking at the date of January 5th.
We had set it for January 4th at noon, if he's available.
He does homicides and CSC cases on the Tuesdays and Thursdays, so that time is not going to work.
Okay, one split second, Judge.
Okay, all right, just let me know.
Looking at my calendar now.
Understand.
January 5th is difficult because I have a doctor's appointment at 1, and I have stuff in, well, wait a minute. Okay, no, that judge is an 8:30 judge that I have stuff in front of. So January 5th, maybe at 10.
I have a 10 a.m. already. I have a 10:45. Does that work for you?
10:45.
I think that's our. Make sure. Okay, 10:45 a.m. on January 5th?
Yes, Judge.
Okay.
You said 5 as in 5th, right? Oh, yes, because
5 as in 5th. Yep, 5. 5, yep.
Okay.
Next Friday, okay? Anything else to be addressed
Right.
at this time?
No, Judge, thank you.
Okay. But
Your Honor, my client, we are waiting for a DSU referral. I didn't want to repeat myself because I don't think that you'll do it without a referral. But this is a case where the bond is 100, I believe 100,000, 10%. And Judge, can you advise if I should address it, or because I addressed it yesterday and it came down to the point of needing a DSU?
Okay, well, if the judge yesterday did it, I don't want you to have the same argument. They felt like it needed a DSU. I'm gonna let it stand there. Hopefully it's been ordered at this point in time, and we'll address bond again next Friday during the preliminary examination.
I'm asking that it be ordered today if it's not been ordered yesterday. Oh yeah, you know what? She said she couldn't order it because she didn't know your schedule. I don't remember what she said.
Okay.
But
Make sure we
yeah.
order a DSU report on this matter today.
All right, thank you.
You're welcome.
All right.
Thank you, Mr. Watkins. You're welcome. You're all set, Mr. Watkins.
Thank you.
You're welcome. That's this morning's docket, I believe.
Yes, thank you, Judge.
You're welcome. Happy New Year to you. Happy New Year, Jim.
Happy New Year,
Thank
Your
you,
Honor.
Judge.
Y'all have a blessed one. That's all we have for you.
Yeah, that's all we had. You took us, you listen, y'all had everybody over there.
And we're trying to clean out this year, start over next year fresh.
That's right. All right. Have a good day. Bye-bye.